Have you ever wondered what happens to a family vacation home when one owner declares bankruptcy? This situation can create significant anxiety for county owners. The outcome of bankruptcy proceedings may directly impact your shared property. When someone files for bankruptcy, their trustee must evaluate all non-exempt assets, including real estate. This evaluation extends to vacation homes and cottages, regardless of joint ownership. In Ontario, bankrupt individuals may keep their primary residences if the equity is below $10,783. However, if the property exceeds this limit, other options may help retain ownership. The first step is for the trustee to determine the fair market value of the cottage through an independent appraisal. They will account for any liens or outstanding debts, calculating the remaining equity. If one person solely owns the property, creditors receive this full equity. However, in joint ownership, only the bankrupt share is at stake. It's a common misconception that properties will automatically be sold by trustees in bankruptcy cases. Instead, options are available. After determining equity, negotiation often leads to selling the bankrupt share to remaining owners or third parties. In contested situations, court approval for the sale may be sought. The key goal remains to secure equity for creditors without losing the family cottage. Avoiding the pitfalls of fraudulent transfers is crucial. Selling a property for less than its fair market value right before bankruptcy can be legally reversed. Families should avoid transferring interests in properties to escape financial responsibility, as this could lead to fraud charges. One appealing option for retaining a share of the cottage is a consumer proposal. This allows debtors to maintain property ownership while negotiating a settlement with creditors. If approved, the debtor commits to debt repayment without losing valuable assets. Jointly owned assets complicate bankruptcy. Some exemptions exist, but joint ownership often makes properties ineligible for these exceptions. Therefore, decisions on bankruptcy should consider potential impacts on all co-owners. Specific Ontario laws protect equity in jointly held properties, particularly matrimonial homes. If the home's equity is below $10,000, the bankrupt may keep the property. Exceeding this amount puts the equity at risk. For separated couples, marital assets pose unique challenges. If one spouse files for bankruptcy, their interest in jointly owned properties is transferred to the licensed insolvency trustee. In turn, this interest may be sold to settle debts, affecting the remaining spouse. Vehicles typically remain with the bankrupt if their equity is below $6,600. For vehicles valued higher, arrangements can often be made to cover the additional equity. For savings accounts, RRSPs are protected from bankruptcy, while RESPs may be subject to seizure. Bank accounts do not qualify as exempt assets, but reasonable living expenses are generally safeguarded. If facing bankruptcy while co-owning a family cottage, remember only the bankrupt's equity must be settled for creditors. Generally, non-bankrupt co-owners may buy out the bankrupt's share. Alternatively, consumers may choose a consumer proposal to negotiate a debt settlement directly with their creditors. This path helps avoid the adverse effects of bankruptcy. If you're exploring your options for dealing with debt, consulting a licensed insolvency trustee can clarify your next steps. With various strategies available, you and your family may retain ownership of shared assets while addressing your financial challenges.